All right. Thank you and welcome to the Indivisible Mass Coalition Immigration Justice Action Team's monthly virtual forum. Tonight we are welcoming two speakers who are going to be talking to us about social justice in Massachusetts and the relationships between law enforcement and federal immigration enforcement. Joshua Dankoff is the lead author of the ICE Out, Mapping and Resisting Local Law Enforcement Collusion with ICE in Massachusetts, a 2026 report that will form the basis for tonight's presentation. He's an attorney and director of strategic initiatives at the Citizens for Juvenile Justice, joining that organization in 2015. He has more than 15 years' experience working both domestically and internationally on questions of justice, sector reform, and human rights. Joshua leads research efforts at Citizens for Juvenile Justice, where he has produced reports on topics including policing, carceral education for youth, the Youthful Offender Statute, and law enforcement communication with federal immigration officials. Joshua has worked extensively with UNICEF, both as child protection specialist in Sierra Leone and as a consultant, and he has previous experience with the Ministry of Justice in Cote d'Ivoire while on a Fulbright Public Policy Fellowship. Javier Luengo Garrido lives in Western Massachusetts and is originally from Chile. He is an organizing strategist and deputy field director for regional engagement with the American Civil Liberties Union of Massachusetts. He has won multiple awards for his work, including a MICA Change Agent Award in 2019 and being recognized by Mass Live in 2023 as an emerging Hispanic leader in the state. He began this work with ACLU in 2017, coordinating the Immigrant Protection Project to support immigrant families. Javier's work focuses on immigration, unarmed alternatives to police, local and state advocacy and education campaigns. He was the deputy field director for the Yes on 4 ballot initiative in 2022, which upheld a law allowing undocumented immigrants to receive driver's licenses. Recently, he has partnered with Luce Immigrant Justice Network to provide Know Your Rights and ICE bystander trainings for the community. We want to welcome you both to this forum. Thank you so much. We're going to begin with Javier, who will be sharing an overview of the history of police and ICE communication in Massachusetts. And thank you. I hand it over.
Thank you so much. I sent a different bio, and I don't know, a lot of that information is either outdated or not correct, just to let you know. Anyway, so we were talking a couple of days ago with Joshua about how to approach this webinar, right? And one of the things that we realize, and it's quite important, is for the community at large and the community in the Commonwealth is to understand the sort of how we got here, right? And it's specifically, we have to go, all the way back to we can go even before the first term administration. I mean, the program Secure Communities, which is one that allows, anybody who gets booked and fingerprint at a local police department, those fingerprints immediately go into the federal database. And that's one of the ways how local police enforcement and federal law enforcement communicate. And all this communication, this sort of, increase after September 11th. Because voices were talking about this, that this can, the September, one of the reasons why September 11 happened was the lack of communication between agencies. So after that, we experienced a full scale, a rampant scale of ways that law enforcement look for to share communication between each other. In the case of Massachusetts, if we go to the first term administration, we understood pretty early that one of the ways how ICE was operating, it's in deep communication with police departments. And most of that communication, it's not based in contracts. It's not based in formal agreements. Most of those communications are handshake agreements and just verbal agreements and understanding that if an ICE officer calls the police department and asks if Javier is there being detained, they confirm. And at that point in 2017, 2018, um, the ICE agent calling would request that Javier if they would be able to hold me at the police department until ICE agents would pick me up. That was how things happen. I live in Northampton, and weekly, the Northampton Police Department, the Springfield Police Department, and other police department would handle people to ICE in that way across the Commonwealth. Um, because we knew this, and we also knew that a lot of the people being taken to the police station fingerprint were during traffic interactions. If I was running a red light, not wearing my seat belt, any traffic violation that would have me in an interaction with police potentially would end with me being arrested and taken to the police station. Many times we realize also that some police department would ask immigration status, control bureau citizenship. We know that if I'm running a red light, I'm not wearing my seatbelt, immigration status, control bureau citizenship is not relevant. But at the same time, the officer collecting that information would be useful at that point if anybody from ICE would call asking for me. The ACLU and other groups partnered to start passing municipal welcoming city ordinance, also known as trust city ordinance. Badly called sanctuary city ordinance. When we're going to talk a little bit about that, why we shouldn't call it like that. And those ordinances are really basic and really, really, really good. What we were seeking to do, and we still do it because we have keep working on this, is to try to stop the flow of information between the local police department and ICE specifically. You would be surprised that most of the information that comes and goes and floats from the local police department to this federal agency is optional, is not mandated by law. This is a context where a massive amount of people were detained, starting during the first Trump administration, some detentions going down to the Biden administration, and now we find ourselves in this massive amount of detentions. Massachusetts have experienced 3 surges of detention during last year. The first one was around 350 people detained. The second one was more than 1,000 during Operation Patriot. And the last one, October, November, was Patriot 2, or more than 1,000 people only in Massachusetts. Informal collaboration and informal communication has helped ICE with police departments, has helped ICE to do this kind of work. One of the reasons why this is so important to understand is because now we are in unprecedented and uncharted territory. We know that for the federal government to be able to accomplish what they promised during their political campaign, they needed more hands on deck. And this is the reason why we know and we have seen that ICE divided in ERO, Enforcement and Removal Operations, and HSI, Homeland Security Investigation, is teaming up with the ATF, FBI, and DEA to do civil immigration enforcement. So many, many, many times, and most of the time, when we're seeing ICE operations in the Commonwealth, we're seeing not only ICE, but these other agencies working in tandem. I would like you to have in mind this context now that I'm going to pass it to my colleague Josh. When we're talking about the reality in Massachusetts, we also need to understand that the reality in Massachusetts is quite different to other states. Sometimes it's worse, sometimes it's better, sometimes it's, quite different. Joshua.
Thank you so much, Javier, and thank everyone in Indivisible for having us here. I really appreciate the background that Javier just gave. It's so important to name 9/11 and as the start of this push to have real coordination between local law enforcement, state law enforcement, and federal law enforcement. That now we have to think of our police departments have been sort of sitting in this and marinating in this idea that they have to work together with federal law enforcement, regardless of what the federal policies are concerning immigration or anything else. And one thing we hope to talk about today is to push back on some of this, right? That some of the power in deciding how information can be shared and what collaboration should look like or shouldn't look like is decided at the local level. So we're really pleased to be here with Indivisible, with folks who are working down to the municipal level and have those relationships. Right, there's still a lot to be done in a lot of municipalities around Massachusetts to improve this. So we're really pleased to be here. I'm going to share my screen and run through a few slides for those who have not had a chance to read through the ICE-OUT report. I'm gonna go through it now, and then we're going to have some time. Javier will talk a little bit more about after that about the PROTECT Act, make some of the connections between this research and some of the legislation that is statewide. And then there's a chance for Q&A. So we're really pleased to be here and very open to questions. So I'm going to jump in. So today, I'm going to talk about the ICE-OUT report that was just released in April and is still very relevant today. If you're not familiar with CFJJ, Citizen for Juvenile Justice, though we have the word citizens in the name of our organization's title, we represent all young people birthed to 25 in the Commonwealth, regardless of citizenship status. For more than 30 years, really focused on juvenile justice agencies across the whole system, with a focus on trying to make the system more equitable for young people and to think about it being more developmentally appropriate. Our work includes advocacy, legislative advocacy, administrative advocacy, research, like this report, public education, here we are together, and community engagement. We work a lot in coalition with the ACLU and a number of different coalitions across the Commonwealth. Just to say a little bit more in setting the stage, we are in a moment of democratic backsliding right now. The Harvard political scientist Stephen Levinsky has labeled the United States no longer a democratic system, but rather competitive authoritarian. So we nominally have competitive elections. They're coming up in November, but the regime is doing all it can to undermine those elections and is acting in a lot of other ways in an authoritarian manner. And part of that is through the detention of tens of thousands of residents across the country, and as Javier mentioned, more than 3,000 in Massachusetts just in the last year. This aggressive immigration and deportation agenda is different in that it moves away from just border security to really pushing ICE agents into our communities. And so it is a shift. It is a continuation of policies on one level from past presidents. And it's important to note that under Obama, there were a lot of deportations. Under Biden, there were a lot of deportations. But there are also changes under the Trump regime in terms of moving a different shift in ICE, and certainly tens and more than $100 billion towards these efforts, just re-upped with another $70 billion. So they have a lot of money to do things in a different and more aggressive way. And we have to just name that they are setting aside a lot of the constitutional norms and civil liberties protections. So it's incumbent on us as people who have the voice and relationships to push back wherever we can. And again, we're pleased to be here. So why is this important to CFJJ, to Citizens for Juvenile Justice? Javier already mentioned this very important decision from 2017, Commonwealth versus Lunn, which prohibited local and state authorities from holding on to a person solely based on a request or a federal immigration detainer. But the Lunn decision and the state law has been silent to date and allows a wide range of communication, information sharing, and collaboration between local police, really across the entire justice system, from police to sheriffs who run the county jails to court officers to district attorneys and assistant district attorneys, and certainly Department of Corrections. So it's one of the takeaways, I think, is that this communication and this information sharing and collaboration between local agencies and ICE that leads to detention and deportation really undermines core due process principles including a presumption of innocence, opportunity to be heard, and the right to an attorney. These are things that are incorporated into federal constitutional rights for people who are accused of crimes, and highlighted also in Massachusetts Constitution and a whole range of case law. But as soon as one of our police officers communicates with ICE and says, no, just go ahead, take this person away, and they're taken into detention, those protections are undermined. So the key question for us in this report was, in our juvenile and criminal legal systems, who should decide when information goes to ICE and under what circumstances? And as a takeaway, most municipal, county, and state institutions that make up our system allow and extensively do share information with ICE, and many collaborate very openly. And that this has negative impacts, certainly on our immigrant neighbors, and it also reduces trusts and co-ops our state-level justice system to act as a force multiplier for the federal administration's really authoritarian immigration policies. And this idea of force multiplier, I want to just cite Peter Mancina in his 2025 book, On the Side of ICE. So in order to document, and our methodology for the report was largely based on public records requests, more than 90 to municipalities, all of the sheriffs, all of the DAs. And there were two requests. The first was around just asking what were the policies that those agencies have around communication with ICE, and what were the most recent communications, and to let us know what records they have around times, instances where individuals went directly from the custody of either a police or a sheriff agency and directly to ICE. And then a second set of requests was around cell phone records and text communications between agencies and ICE. So we did this to more than 60 police departments. I'm just going to drop in the chat if you want to look at the actual records and consider, this is something that you can take place. You can do this, right? Public records requests are not, they're free to do, and you can send this to your agency if we haven't already. And we'll get to that. We've collected that, but just want to share that we really hope to move folks to action. So I'm going to share some of the key findings that move sort of thinking about the system pre-arrest, and then at the point of arrest is really important, and then things that happen later in the system. And again, this key question, when do agencies communicate with ICE, and when should they, right? That's for us to think about. So one of the things we saw pre-arrest is that fusion centers and automatic license plate readers really facilitate the sharing of information and surveillance information pre-arrest with the Department of Homeland Security, DHS. So in Massachusetts, there are two fusion centers. These are BRIC, the Boston Regional Intelligence Center, that covers Boston and a few surrounding communities, and then the Massachusetts Fusion Center, run out of the state police. These are interagency intelligence, I'm putting in quotes, as their words, that are collecting surveillance data and can and sometimes do share it with DHS. There are DHS officials sitting in Boston Police headquarters in the BRIC. And there are legal agreements that require BPD to provide DHS access to its databases, to reports, investigations, other information. Just to note, those legal agreements are in conflict with the Boston Trust Act that say that they cannot share things. So that these things play out at the municipal level, and all municipalities in Massachusetts, their information flows into one of these two fusion centers. And the automatic license plate readers are an area, again, pre-arrest, where police are surveilling and collecting information to people driving around. And this information, you got to look at what the contract says. This is municipal contract with these license plate reader companies, and many of these contracts allow ICE and other federal agencies to use that information and track people and query where they're coming from. Another finding is around BRIC, the Boston Regional Intelligence Center, and other police departments' uses of gang databases that raise a lot of concerning questions, certainly around racial disparities and around civil liberties. These gang databases have been documented as being racially discriminatory and ridden with errors, and disproportionately target Black and Latino residents. If there's a 2022 First Circuit Court of Appeals case that denounces Boston's gang database, calling it an erratic point system built on unsubstantiated inferences. However, getting labeled as a gang member really has massive impacts for people who for their immigration case. If you qualify, would have otherwise qualified for asylum, or if you are just trying to put in an application for a SIJ, special immigrant juvenile case, but you're labeled as being gang involved, it really tanks your case. It really has massive impacts. So we have these city level systems, surveillance systems that pull information in, label certain people as being gang involved, and then the impact of that, even again prior to arrest often, and the impacts for that on their immigration cases are real. We know that some of the DHS grants, Department of Homeland Security grants to the municipalities require cooperation on immigration enforcement. Just to mention one grant, Boston had applied for the UASI grant that requires 10% of its funds to be spent supporting collaborations between state and local law enforcement and ICE. There's a court challenge on that language specifically from Illinois, so it's put on hold. But these, again, there are lots of ways where the federal government is putting pressure on municipalities and the state to encourage this level of collaboration that we see. And I'm going to talk in a minute in a little more depth about the policies. What's new and unique for this report is that we pull together these policies, police level policies. These are things that are signed, passed by police departments and police chiefs. And these policies themselves, some of them are really troubling. One of them that is adopted by at least 4 municipalities in Massachusetts, but written by this company Lexipol, which is a private company that provides policies and services both to law enforcement and also to the carceral system, allows officers to detain someone who's just been lawfully contacted, so not yet arrested, lawfully contracted, and to contact ICE if they have a, quote, reasonable suspicion of a criminal immigration violation. So this is putting our local police specifically in a role to investigate and know the difference between a civil and criminal immigration violation. And if they have suspicions, to then detain them specifically against the Lund decision. And we've brought this to the Attorney General's office and looking forward to action and changes in these policies. But the ICE makes it very easy for law enforcement to pass information. They run what they call a law enforcement service center that is nationwide. They run a 24-hour hotline where local police can call for guidance. So as Javier mentioned, police are out in the community, they pull someone over, they run their name, they run their license plate, or they run their driver's license, and they get a ping that perhaps there's an immigration detainer. An immigration detainer from ICE is a request. It's a voluntary request to hold on to a person. If you're a local police officer, maybe you don't know what this is. And so ICE has this phone number. Call us. We'll provide information. And they're happy to guide people on what to do, and they'll ask them to hold on to them. One of the things that we asked for in our public records request is phone call records between local police officers and police departments and that law enforcement service center. And then finally, Boston Police has an MOU with ICE that designates certain BPD officers as customs officers who, again, can directly assist ICE in criminal immigration enforcement. You've probably heard of 287G agreements. These are agreements that deputize police or carceral agencies and their agents to be ICE agents. We do not have any in Massachusetts at the police level or sheriff level. The only one is the Massachusetts Department of Correction. But everything that I'm talking about here, all of this collaboration and cooperation that Javier and I are talking about, this happens outside of the 287G agreements. So it's important to say there should not be new 287G agreements. And also, this communication collaboration is ongoing and goes beyond that. So at the point of arrest, as already mentioned, the current fingerprinting process following arrest results in automatic information sharing with the FBI and ICE. The state law requires fingerprints only to be taken for felony arrests and only felony arrests under Chapter 263, not under 94C, some of the drug offenses. It does not require fingerprints to be taken for misdemeanors, the lower level offenses. In practice, police across the Commonwealth in almost every municipality are doing fingerprints for everyone felony, misdemeanor, regardless of the level of offense. And the requirement in regulation is that they then have to send fingerprints. Again, they only have to send felony fingerprints taken to the state police, who then send it to the FBI for an identification and warrant check. And then once the FBI has it, as Javier mentioned, this Secure Communities program, the ICE can access that, and they do access it. So it means there's, at the point of arrest, minutes after a fingerprint is taken locally, it gets sent to the state police and to ICE and to the FBI and ICE, and the communication can then have it. So for us at CFJJ, what really piqued our interest were these arrests in Chelsea and Everett in 2015 of 13 and 15 and 16-year-olds. They were arrested by local police, and within a couple of hours, ICE came and took custody of these 13 and 15-year-olds directly from the police department, right? So this, and the explanation from those police departments was, well, it was the fingerprints, right? And that is a plausible story. It is possible. But there's also a lot of communication outside of that that we're trying to document and make sure that policies really slow that down. And one thing that you can ask is, who are you fingerprinting? Are you fingerprinting everyone for a misdemeanor? It's not required by law. And by you, I'm saying you can ask your police departments and you can ask your local police. And at the end, we'll get to an advocate's toolkit that really provides a lot of specific questions there. So we put together this data set of police policies and found that more than half of the ones that we collected, or that we contacted anyway, have policies that allow or require information sharing or collaboration with ICE. A little less than half do not have any policy. Some departments don't have a policy but refer to a city's immigration ordinance, one of the trust acts, or something else. And then a few departments have restrictive language about information sharing. We're still waiting for the state police and a few other places to respond. It's a whole other discussion around transparency. Just really quickly, among the places that do have policies is the police level policies where the municipality can decide, right? I'm just going to name a few of the worst offenders in terms of language that they have in these policies. In Quincy, for example, they require an IAQ, immigration alien query, that's their words, not mine, for every foreign-born person who is arrested, and mandates notifying ICE of bail determinations and pending releases. So it's requiring, this is beyond the fingerprints, it requires the police to share information with ICE. In Everett, it allows individual officers to collaborate with ICE if it is seen to be in the public safety interest. And that allows the individual officer to decide. And so again, when we're deciding who should decide, maybe someone should decide, but it shouldn't be the officer on the ground who's making that decision with no guidance. I already mentioned the Lexipol policy, and in Holyoke, they do a query on an immigration query on everyone who's arrested, and officers are told to contact ICE if there's any detainer or deportation order found. So as I mentioned, a number of places do not have any policy in place, but it's important to note that that doesn't mean that your town is in the clear. That just means that officers do not have any guidance, and it is up to individual officer discretion to decide when to share information with ICE. A few places, as I said, there's no policy, but they refer to a Trust Act ordinance. Boston's on that list. Lawrence is on that list, though. When we made a public records request about that, the Lawrence police said, yeah, there's some document, but we don't even have it. So they don't clearly always feel constrained by these Trust Act ordinances. And then finally, there are a few places, Brookline, Bedford, Somerville, I'd probably add Shrewsbury even after the report came out, that have pretty restrictive policies ordering police not to do status checks and to specifically mention the chief, right, to not allow the lowest level of officer to be able to make these decisions, but to at least put it up the chain of command. Overall, these more protective policies are the exception, not the rule. And in the report, we talk about some of the things that make policies stronger or not. I encourage folks to look at that. I see there are some questions in the chat specifically on this. I'm going to just pause if I can, with Javier's permission, and maybe just we can both try to answer some of these Paul's questions. I'm going to go in opposite order just because that's what I see. So says the lexical policy says lawfully contacted. Is this as little as a traffic stop for minor infraction? Yeah, lawfully contacted just means that it's not the police just coming up to you for no reason. They have to have some limited level of suspicion to be talking to you, but that is not as much suspicion as being detained or being arrested.
I would,
And go ahead, please.
yeah, I would add, so we're doing a substantial amount of work in know your rights for immigrants and undocumented folks to be able to protect themselves knowing their own rights. And traffic stops has been widely used to target people and to sort of move people into a position where they are exposed to being detained by ICE. And we're talking about minimum traffic infractions. Massachusetts, a little more than 2 years ago, passed Work and Family Mobility Act when people would be able to obtain driver licenses. So what we're seeing is, having to work with the immigrant community in relationship to traffic stuff, what information is relevant, what information is required by them to share. But traffic stops, like regular traffic stuff, simple traffic stuff, from a burn light to using, the universal pretext of having something hanging from your rear view mirror as blocking the view to escalate and using those as a primary reason for the stop.
Thanks so much. Another question, must law enforcement inquire about immigration status if they have someone in their custody? Law enforcement, they do like to identify people. And one of the ways they will identify people if they don't have a driver's license, a Massachusetts driver's license, is to ask for identification. And if the only identification that a person has is a passport from elsewhere or an identity document from another country, then that can be something that is a sort of valid reason for law enforcement to ask. But no, they are not required. If they have a Massachusetts driver's license, they're not required to ask someone's immigration status. Javier, you can add to that if you'd like.
Yeah, one of the things that we have talked widely across the Commonwealth is that neither state police or local police departments budget or enforce federal immigration law. It's that simple. And again, what Joshua keeps restating and I saying too, they are opting to do it. They are willingly knowing that those actions are targeting a big portion of our neighbors, and they unilaterally opt to do. I mean, I know that Joshua are going to talk about the toolkit that you guys have, but we're going to talk a little bit about being having a healthy dose of skepticism and ask the right questions in your own community.
Yeah. Thanks, Javier. I appreciate that. There's a question about Shrewsbury as being identified as one place that has called the LESC, the Law Enforcement Service Center that's run by ICE. And is there any valid reason for them to have called this number? I don't know why. When we got the records, we just know that there was a call. We don't know the substance of the call or a recording of the call. I can't think of a valid reason right now. Perhaps if there was, I would hope that they were not calling in response to a specific individual in their custody. That's what I would say. If they had some general questions and wanted to ask, and at least hear ICE's take on what they should do, I imagine that could be valid. And then finally, there are two questions about the license plate readers. Anything to say about businesses using them, and Home Depot is mentioned, and are these police vehicles, the mobile license plate readers, the same in regard to those sharing as static systems? I'm going to first ask Javier. I don't know actually as much about these as perhaps Javier or others at ACLU do.
Yeah, I mean, what I can say, so let's I'm gonna keep your order. So I'm gonna from the last one. In relationship to Are mobile IPR systems on police vehicles the same in regards to sharing as static system? Usually, the static system that we talk, it's mounted to a cruiser, right? It's owned by the local police department, and it's under, the jurisdiction of the local police department. The mobile L the I mean those are the mobile LPR systems that are part of a cruiser, that are around the city. The pole ones, um, usually those are in contract with infamous companies, and I'm saying it's famous because they help to this massive dragnet surveillance level at the national level, which is Flock, right? Would be interesting at some point to see how many of these municipalities had Flock, and that's a system that cities can pay for, and it's a gigantic database with LP. It's a gigantic LPR system where cities can opt in or not to be part of that system. Information sharing. If Flock runs nationwide queries, they can actually go into the databases of those cities that have not opted out of the query, and that information can be shared depending on the policies with pretty much anybody. We know that California has had a lot of issues related to automatic plate readers and ICE. I know that the city of East Hampton had Flog. Cambridge, I think, not recently walked out of their contract with Flog, and the same with the city of Greenfield in Western Mass.
And just to say, Flock is not the only company. Motorola is a bigger provider, and
Motorola
especially
Solutions.
yeah, as
Yeah,
Flock has gotten a sort of negative press, we see some departments, municipalities shifting attention to Motorola because they think they can get under the radar.
yeah.
I'm gonna.
The city of Northampton signed a dashcam agreement with Motorola Solutions a couple of years ago.
And Boston, I think, is starting again a pilot regarding these license plate readers. Well, you'll probably hear more about this in the coming months. And just to say, the Protect Act does not touch any of the automatic license plate readers, as far as I know.
That's
I'm
correct.
going to keep going on a few more of the findings and in the report, and then some of our recommendations, and then we'll return to questions. One thing that we looked at as well is the data from the Deportation Data Project that show that at least 200 ICE arrests, when this is ICE data itself, when they say, where did this arrest take place? ICE notes that they took place at local police departments in Massachusetts. And so they noted 32 of these departments. And the chart is here. It's very tiny, of course, but Lawrence, Boston, Lynn, and Milford are the most frequently named police departments. But again, there are more than 30. And as noted, we've already talked about Tewksbury here. Tewksbury, their police department had an individual who was on bail, who was held, and after bail was posted, they transferred the person to ICE. And we have these text messages back and forth between officers saying, what should we do? And they read the policy, it was the Lexipol policy, and said, oh, well, we can detain them. And so this isn't just a theoretical question, right, of what these policies are doing. We know that these policies are something that are in use. And when people, the impacts on this are, again, for everyone. When people in the immigrant community fear police contact, and if they fear that police contact can lead to deportation, that reduces crime reporting, which has a negative impact on public safety. So one thing to just note, this is not just impacting the immigrant community, this is impacting everybody. And finally, after arrest, all of that had to do with the sort of the initial police contact. But just to say, other agencies in the justice system, from the trial court, even some DA offices, and certainly the adult carceral system, they facilitate extensive communication and collaboration with ICE. So just to mention, the sheriffs, most of the sheriff's departments share really whatever information ICE asks for. And they proactively alert ICE before individuals with detainers are released and go to court. There's before they changed their policy in Bristol County, the sheriff offered to send ICE daily booking lists of all new commits every morning. And the sheriff's departments also were quite difficult with us in providing records, and we had to litigate against them. And we're just now getting some records after some ongoing litigation. The trial court, there was a question in the chat about the trial court. More than 700 ICE arrests have taken place in Massachusetts at state level courthouses since January. And this is just between January 2025 and February 2026. So the number is certainly higher. More than 700. The trial court policies allow the sharing of information with ICE. They don't allow court officers to offer information, but if asked, they can answer, yes, this person is here, this person's in our custody, or oh, this person is about to get released. And ICE is also allowed to enter court facilities. Just to say, the trial court, in its own inherent authority, does not have to allow this to happen. Other states, Connecticut, Oregon, New Jersey, they have put in rules that limit ICE activity in courthouses, and this is something that we've written about and put pressure on the trial court. Seems like their trial court is waiting for the PROTECT Act to come down. And just to say, there's a question about the PROTECT Act regarding courthouses. The House and Senate versions differ on this. The House version does not allow arrests within courthouses, and the Senate version is a little stronger. It says does also within courthouses, but also on court property. That's important. So ICE is not just standing directly outside the door initiating arrests. And we have also documented from district attorney offices some unsolicited communications from specific ADAs who are there to prosecute, and they're called the Commonwealth. They're there to prosecute crimes, but for ongoing cases and specifically alerting people to alerting people to ICE and saying, please arrest this person. We saw this in both Hampton and Suffolk County. So just to run through a few recommendations that we say in this report, and again, the report was late April, so some of the language around towards the legislature is a little dated, but we'll provide some updates today. Just as some general recommendations across all of the justice level agencies is defend our state level justice system institutions, right? Do not undermine your own justice system by informing and allowing people to just be pulled out of our justice system to go into ICE custody. These are our own justice actors. They should let our justice processes, they're flawed as they might be, they should let those processes move forward and not let people get pulled into ICE custody and deported. And secondly, it's important to avoid policies that further this false good immigrant, bad immigrant narrative. Right? This goes back to this question: who should decide when information should go to ICE, and also under what circumstances? About whom? Is it okay if someone has been stopped by the police for a traffic infraction? Is that enough? If they've been arrested, is that enough? If they have been held pre-trial at a county jail, is that enough? For me, it's very clear. No, the answer is no. That's not enough. And we should let the state level system do its work. But we've seen some leaders, including our governor, unfortunately, sometimes talking about people who are justice system involved, no matter the level of justice system, as being sort of bad and deserving to have information shared with ICE. Our recommendations to the legislature is absolutely to adopt as most expansive version of the PROTECT Act as possible, that include really strong guardrails on law enforcement collaboration and communication. We would include some recommendations that go, one thing that PROTECT Act does not include are bans of transmission of juvenile fingerprints to FBI and ICE, although that is something that CFJJ has been recommending for at least 3 sessions. I've mentioned here House 1657 and Senate 1058 just in the current session. And that we need to make sure to include the sheriffs in all of this. And unfortunately, none of the PROTECT Act touches district attorneys. There's nothing that limits their ability to share information. We think it's important and recommend increasing guardrails on police surveillance. really a comprehensive rethink of gang databases would be in order. And at least putting in some guardrails to require notification, mandate regular audits, and restrict its use in immigration court. Again, limiting the use of license plate readers and facial surveillance. And certainly to the trial court to enact its own rules and not just wait for the PROTECT Act that limits ICE in ability to enter and certainly ability to make arrests in courthouses. And a recommendation of the governor to cancel the one existing 287G agreement between Massachusetts Department of Correction and ICE. This is the only Democratic governor in the country that allows the state Department of Correction to have a 287G agreement. And this is very relevant for all of you. The recommendations down to the municipal and county level that our municipalities, police departments, and city councils and mayors, to the extent that they can, use their powers to set clear guidelines that limit ICE collaboration and information sharing. And in terms of accountability for our Attorney General's office and the Post Commission, Peace Officer Standards and Training Commission, to specifically pay attention to this question of information sharing and provide oversight and hold officers to account if they break those rules. So in closing, before talking about the advocate toolkits, this is not just about immigration, right? This is about democracy much more broadly. And if our local police officers and institutions have these close relationships with ICE that allow this harsh response to immigration, it's going to be much harder to disentangle and ask our local police to not just be buddied up to ICE if they are asked to, quote unquote, monitor our local elections, right? Or have any other roles. We've already seen ICE come into our airports during the government shutdown. So we don't know. ICE is not a legitimate body right now. They're acting unconstitutionally, and to have our local police act as force multipliers to do their work for them and have these close relationships is really troubling, not just for the immigrant community, but for us overall in democracy. At the end of the report, we have an advocates toolkit that allows for and encourages analyzing immigration enforcement policies and pushing for local change. And I'll just note one piece of that, which is this page here that have questions to ask your local police. If you're to go to a police chief or you're to go to a mayor, ask these questions and make some of these demands. And very importantly, once the PROTECT Act passes, and we're very, very hopeful and confident that it will, this will shift a little. We're going to make changes to the advocate toolkit to update this and make it relevant, because there are going to be new obligations put on our local police for this. So I'm going to stop sharing my screen and we'll move to question and answer, but thank you so much for this and interest in this. Javier, I want to turn it back to you. Do you want to talk a little bit more about the PROTECT Act and then do questions? You want to answer some of the questions? How do you want to do this?
Let's go with the PROTECT Act. A ton of the questions are related to that.
Excellent.
Let me hold on. I'm gonna there you are.
And I'll just say I'm going to drop my own email in the chat. If you have questions about what's happening in your own municipality and want to do some of these work or want to report back on how helpful or unhelpful the municipal advocate toolkit is, please reach out. Let me know. Happy to be as helpful as I can be.
Excellent. So we're gonna move to the PROTECT Act that is right now in conference committee, which means that the House has passed their own version of the PROTECT Act and the Senate has passed their own version. Now both versions are merging into the conference committee that has members of both houses, of both chambers. Just to do a level setting exercise. So what is the PROTECT Act? It's the consolidation of multiple existing bills, new policies, and executive orders. And was started by the leadership of the Black and Latino caucus, with Rep. Andy Vargas being one of the leads. The major themes of the PROTECT Act are, again, this is coming back and back, and we want to really double down on this. limiting voluntary law enforcement collaboration with ICE. The vast majority of what Josh talked, it's voluntary collaboration, optional, not mandated by law. Also, one of the major themes is protecting access to courts. We want people to be able to go to the courthouse if they have to go. We want survivors of sexual violence, survivors of any kind of violence, being able to report those crimes, going to the court or going to the local police department, and not feeling that if they go, they are going to be set out and they're going to end up in ICE detention. And also what it looks is addressing sensitive locations. Sensitive locations started during the Obama administration. That was an executive order by the Obama administration talking, the executive commanding ICE that do not spend any resources or don't do operation in health facilities, educational facilities, and house of worship. The current status of the protected ads, we
Javier,
have.
I just want to say I'm only seeing your first page of your PowerPoint. If you're meaning to move it on, I can only see the first one.
Can you see the second one there?
Yes, now I see the second one.
What about there?
Yeah, great.
Excellent. So the current status, the version passed by the House is H 5316 and the Senate is 3072. And they are in conference committee where all the different versions are negotiated to merge and come with one single bill. The expected timeline, so the conference committee bill should be out around mid to late July, probably more late July. Returns for a yes or no vote in each chamber, which we're expecting to be a positive one because you have members of the House and the Senate being part of the conference committee. It passes both chambers again. It would go to the governor for signature, veto, or amendments. Can you see my next page?
It still says, what is the Protect Act?
Excellent. So you cannot see my next page. Okay. Okay, there you are.
Yeah.
Can you see the no new 287G agreement?
Yes.
So, as Joshua said, the only standing 287G agreement is with DOC, with the Department of Corrections, and the 287G, it's a deputization contract. I always like to use the movie The Matrix for this kind of example of what a 287G is. If you remember The Matrix, when Neo is in the training matrix with Morpheus, and they are in the fake matrix, and Neo looks back and there is a fake agent pointing his gun, Morpheus said, anybody who has not been disconnected from the matrix is a potential agent. So it happens that for example, the New Hampshire state trooper body has a 287G, which means that it's not only a state trooper in New Hampshire, is not only a state trooper, but also a potential ICE agent. This is how the deputization contract with 287G functions. So these contracts allow local officials to be deputized. There has been a massive escalation of 287G across the nation. A lot of the leadership from ICE and DHS has given talks in different settings to the National Sheriff Association and police associations, where they are saying that 287G are sensitive to carry the Trump agenda in immigration enforcement. Massachusetts used to have 4 agreements. Advocates cause all but one to end. The only remaining is 287G is with the Department of Corrections. And these agreements are not related to detention. When we're talking about the caging contracts, which allows a detention facility to have an ICE section, then we're talking about IGSA contract, which is the Intergovernmental Service Agreement. The only one remaining in Massachusetts is with Plymouth County Jail that has an ICE section. It used to be one in many other places, including Bristol, Greenfield County, and so on. What the bill says. It says no to new 287G agreements. Both version and the House and the Senate says no 287G agreements and no new 287G. Both versions allow the only existing 287G to exist, which is the Department of Corrections again. The House version ban on new agreement includes an exception, which is, it talks about a public safety exception and for a limited amount of time. The Senate bans completely any kind of new 287G. As you should talk, we're seeing a lot of arrest of community members going to the courthouse or leaving the courthouse. In Springfield, Massachusetts, has been, even ICE ambushing community members going in their cars to court. So related to ICE arrest at courthouse, both versions ban all civil arrests in courthouses. The House version applies only inside the courthouse. The Senate version applies to both inside and on courthouse grounds. One of the things that I stated at the beginning is the Protect Act is the mix of many other bills and policies and executive actions that had been going on for the last couple of years. One of those, it's attached to the Welcome City Ordinance for municipalities, that it's about the question about immigration status, right? Both versions generally prohibit law enforcement from asking members of the public about their immigration status. We know that it's not relevant when we're talking about regular traffic stuff and other kind of stops. Both the House and the Senate have limited exceptions for criminal matters with some difference in the approach and how they do it. The Senate version also applies to core stuff, which is really important, which is one of the things that just talk about the core like sharing information and data. The Senate version would forbid anybody working in the court system to be able to share that information. In relationship to the sharing of information with ICE, both versions, the House and the Senate, prohibit police and sheriff from initiating contact with ICE, but allows them to respond to ICE outreach. I know that so the Senate versions include some additional hurdles for ICE, which the request for information has to be in writing not older than 30 days. Both versions have an exception for sharing information about criminal investigations. The Senate is the only one that explicitly says that municipalities can further restrict how they communicate with ICE. House language is not explicit about it, but this is really important, even more so with advocates at the municipal level when they are advocating with their city council, with the mayor, with the police, with the police force. The other section is the use of local and state resources. Both versions, the House and the Senate, prohibit the use of state or local resources for civil immigration enforcement. This is really broad. It possibly can encompass many informal activities and may be useful in the future as ICE pressures localities intensify, which is threatening municipalities, threatening state with withholding money or not giving certain amount of money that was pending. The Senate version has some specifics that are additional to it, such as police may not investigate, question, or interrogate a person for the purpose of civil immigration enforcement, which is extremely important. In relationship to sensitive location, schools, healthcare facilities, childcare centers, houses of worship, the House version requires the governor to publish multilingual guidelines on how public and private institutions and local police should respond to immigration enforcement. The Senate bans civil ICE arrest at these locations and requires this institution to adopt model policies on how to respond to civil immigration. Hopefully there are going to be some good questions in relation to this specific point. The protection for incarcerated person, including ICE detainees, only in the House version, Massachusetts prisons and jails must, one, inform of legal rights and legal services at intake, including right to refuse interview with ICE in own language or through an interpreter, guarantee daily calls with attorneys, provide a public phone number for callers to confirm custody and in any transfer. I want to just talk about two sidelines to this. The first one is just to say it out loud, probably most advocates know, being undocumented in the country is a civil infraction. When somebody is being detained because of a civil infraction, law enforcement executing the detention are not required to read your Miranda rights. So having in any way, shape, or form, in some way, being able to inform people about the rights and the right to decline interview with ICE, it's really important. The other, in relationship to provide public phone number for callers to confer in custody and in transfers, this is also really important. There has been in through the waves of detention, the surges of detention, times where somebody's detained, moved to one of the detention facilities in New England. We're talking about um, two in New Hampshire, two in Vermont, one Wyatt in Rhode Island, Plymouth, and after that they are sent out. It's really, really difficult to find somebody in detention, and it's time sensitive for relatives, for attorneys to be able to find people in the system. Many times, if you go to the ICE detainee locator, it takes a while for somebody to show up in the system, and there is nothing in the state bill for legal for the attorneys or advocates to be able to find somebody easily, and they are at the mercy of the person answering the phone in the other side in the jail. Reverse section 1983, which refers to federal law, allows individuals to sue state and local government officials for civil rights violation. The Senate version allows individuals to bring a lawsuit in a state court, both for state and federal officials for constitutional violations. It may allow people harmed by ICE agents to sue in a state court. I-9 audits, votes version the House and the Senate require employers to notify employees within 48 hours of I-9 inspection request. And also, the Senate only creates a standing legislative commission dedicated to immigration issues. I'm trying to go fast so we have plenty of time for questions. From the ACLU, what's next for cities and towns if the Protect Act is signed? First, education. A lot of the municipal work and a lot of the local advocacy is going to depend heavily in the version that comes out. It's really important as it comes out for advocates to get the right information. Probably we're gonna start doing a ton of webinars and a ton of town meetings to be able to talk about what is coming down the pipe, what is being signed by the governor. So local advocates can go back to the municipalities, to the police chief, to the city council and mayors to advocate for the sort of the better implementation of the law. And also in many places, municipalities are going to be able to go further than what the state is going. The other one is about information gathering. A healthy amount of skepticism is important. Many times, and I'm originally from Chile. I have been living here since 2000. When was it, 2008. And one of the things that really surprised me is that people don't understand that if I go to an elected official or I go to my police chief, and I mean, the police chief or the elected official, it says, well, our values don't allow us to do that. That's fantastic. But there is nothing better than codification, codification, and codification. Codifying allows the creation of training for law enforcement, allows a rule in a process to follow, and also allows advocates to hold accountable elected officials in local police departments, and also allows for the flow of information. So if advocates are filing public record request, they can actually know what to ask for and be really specific and get the right information, and seeing if the existing law, in this case, the Future Protect Act or the existing municipal law, are being followed. One second, and get involved. The QR code if you want to sort of find out who is your legislature, and you can advocate for the Protect Act. And if you are interested after the law is passed to work in your municipality, they ACLU, we can help with that. We have worked in most of the municipalities that had passed some kind of codification to the flow of information with ICE, so the relation between the local police department and federal agents. And you can email us at municipal@aclum.org. So I'm gonna stop sharing my screen. And we can go to the fun part, which is gonna be the questions.
Thank you so much. Stella Coe, one of our co-leads, is going to be checking the chat to see if there's any questions that we've missed. Stella?
I think Joshua is extremely thorough. He's hit just about all of them.
Oh, sorry, wasn't
No,
we
no,
should
no,
bring them up
that's
in anyway.
great.
Not everyone's
It's
reading the
good.
chat, so ask them
So
again.
okay, I'm gonna go from the most recent backwards, just because there's one asked, do we need local bylaws that restrict all information sharing in absence of judicial warrant?
So I'll just say we are hopeful that the Protect Act will pass, and we should see it as being a new floor, which is a higher floor than currently exists, but it's just a floor. It's going to be state level guidance and very helpful guidance as really whatever comes out, although there are meaningful differences between current House and Senate version. But as a floor, municipalities can do better than that. So, and they should. So the suggestion there around, limiting the type of information that can and under what circumstances information can flow to ICE, that is one way. Another way would be to say information. If information is going to go to ICE, only the police chief can sign off on it, right? Put in administrative friction on these decisions and not allow anyone to decide within a police agency.
Great, thank you.
Javier, I don't know if you want to add to that.
Sorry.
Yeah, again, the Protect Act would be the floor, but for any kind of these municipal bylaws or ordinances to be successful, communities should be highly engaged, right? Because they may be procedural risk in many places where, because of how things function, they may find a backdoor, they may find a way, an exception or a way to do it. For example, I live in Northampton. I'm in Northampton, and after George Floyd was assassinated, a lot of advocates did a lot of rallies, and I noticed that a drone was flying above us, and I filed a public request to Northampton. The amount of times that I have heard Northampton advocates saying, my police department is different. It's different. It's sort of that exceptionalism. Well, healthy amount of skepticism. I filed a public record request. I included also, just in case, any kind of text message communication. And what I found, that people at the BRIC, the Boston Regional Intelligence Center, communicating via text with the drone operator, asking if they can get live access to the footage in Northampton. So when the Protect Act comes out, when we figured it out, all the additions that can be made, it's important that the community doesn't drop the ball. Elected officials answer to you. Your city council answers to you. Your police chief answers to the mayor. The city council approves the police chief budget and the city budget. As long as you're able to hold your elected officials accountable, and they proactively work in these kind of policies and to keep them ongoing, it's really important.
Thank you. So kind of in the vein of being involved, do you think that, is there a benefit in advocating directly to the conference committee members to get the floor passed?
No, you go ahead first.
I would say that elected officials like to hear from their constituents. So I think it's public, the list of conferees, and would be important that the target should be specifically, they really care about the people that live in their district. If people also wants to talk to their all representative that may not be part of the conference committee, also do it, because it is important that not only the members of the conference committee hear from the community, but also all the rest of the legislature. Remember that whatever the conference committee comes out with has to go back to the House and the Senate for a vote. So it's important that the entire legislature hears the community.
And the only thing I would add to that is you can ask your legislator to where you are a constituent to contact members of the conference committee about specific things.
Great. Okay. So what if you didn't see your own town in the list when you were showing the different towns and the different levels of agreements? Should we be worried? What do we do? What does that mean?
Well, I was going mostly by population. So if probably you live in a smaller town, and
So
that's
this was
fine.
specifically asked about Worcester, which is
Or they didn't write back to, they didn't respond to the public records request. That's probably the case for Worcester. I'm happy to chat with you with Worcester folks if they want. Yeah, it is. Managing public records requests takes a lot of time. 60 was covering more than half of the population of the Commonwealth, and every town is important, and there are people living, immigrant communities throughout the Commonwealth, and people moving through small municipalities as well. So it was not an oversight. It has to do with responsiveness to public records.
In relation to Western, I had been in communication with Councillor King, and he's highly aware of what's happening at the legislature and the need to use that as a baseline for a municipal bylaw ordinance that is going to go further. So I know if you want to, it would be good for you to connect with Councillor King, because he has been thinking about this. We had been in constant communication related to this matter.
Thank you. Okay. How can the Post Commission be reformed to make it a true accountability tool?
Joshua?
Yes, well, I might not answer that full question. I will just say the Post Commission, in addition, so the Post Commission, the Peace Officer Standards and Training Commission, is a statewide body created after George Floyd's death. They have so far mostly been spending, they've mostly been certifying, and also have with the power to decertify individual officers for misconduct, and they have done so in some cases. Because prior to this, if an officer got fired from their job in one town, they just applied for one in the town next door. Now, this was meant to close that loophole. What they're working on now, which I think is relevant to this and to many questions, is police department level standards. And they have not yet promulgated regulations that would basically require for departments to be, I don't know if they're going to use the word certified or accredited. They would have to have standards and policies on a certain number of things. So they're working on that now, and I have pushed them to include specific language around immigration and ICE enforcement. That they are, so I'd say pay attention to what's happening there.
Great. Is it possible to add a recommendation to the PROTECT Act that it's not already in the House or Senate version or in one of the amendments that is in the Senate?
I'll go first there. I'd say it's at this point, things are, pretty far along in the stage in recommendations, and the PROTECT Act does not answer all of our concerns. It would be an improvement. It's a new floor on certain things, but as I said, it does not touch fingerprinting. It does not touch district attorneys. It does not, and there are meaningful differences between the current House and Senate versions, and a whole host of other things that are really important. So we should not see this as when it passes, and I'm hopeful and confident that it will pass. That doesn't mean we're done. We've talked about already the implementation as a really important thing at the municipal level. And also, these other questions and other recommendations should be stated now and should be the basis for further action in this area at the state legislature.
Javier?
I agree with Josh.
Is there any Massachusetts legislation in the pipeline that will stop the courts from cooperating in or, oh wait, we already got to that, sorry. Oh, I think I caught up. What kind of provisions do local municipalities need to include in their local bylaws to address these issues? Did we hit that?
We didn't hit that. And I'm going to ask a follow-up question to Javier because in 2019, sorry, Javier, I'm putting you on the spot. In 2019, the ACLU put out a model policy, 2019-2020, a model sort of Trust Act like piece that we've seen. Is that strong enough? Is that still the model, or are there other things that you would recommend?
So from 2019 to now, we have updated the sort of the model policy. The reality is that, as everybody knows, the way how the flow of information has changed dramatically, but like grew up exponentially. Plus, in the way how this administration is targeting, we came out with a newer version that pushes municipalities to have policy and trainings in relationship to federal law enforcement coming to your municipal building, to your public schools, and requesting to enter. Those are sort of partially in the Protect Act now, sort of some components in relation to uh, making by law that schools, house of worship, and health centers have to have, including daycares, have to have policies related to how to deal with federal agents at the door. As soon as the Protect Act passes and is signed by the governor, I'm also highly hopeful, like Josh is. We will come out with an updated version based in the new landscape. But again, I'm gonna triple down, 10 times, double down with Josh. This is gonna be the baseline. This is gonna be the baseline, and the success is gonna be community advocates, our neighbors at large coming together and working in their communities to improve the baseline and to make sure that everything changes.
Okay. Here's one more. Is it fair to say that according to the Massachusetts Senate version of the Protect Act, the state is trying to ban or limit civil arrests in sensitive locations by creating a rule that no civil arrest can happen in specific protected spaces without a judicial warrant or court order? And if so, would that rule be effective and enforceable against ICE?
Um, Fernando Leon, my colleague. How are you, Fernando? Fernando is an ACLU trainer.
Thank you.
So it's complicated. Josh, I see your face. It's complicated. The state generally can regulate the amount of communication and the way how employees of the state and the Corps interact with the federal government when it's not regulated by federal law. Gets a tiny bit more complicated when we start the conversation in relationship to the state government, sort of trying to regulate where federal agents can do operations or not. Is that good enough?
I'll just say that is a good question, and that is a tough one. It's a tough one. The police are really concerned about this, especially the question about enforceability. And so it was something that made it into the Senate version included indemnification, legal protection for police should they enforce something. For example, this passes and it says no ICE arrests in hospitals. And then if ICE comes into a hospital and the hospital calls the local police and it sets up this conflict between local police and ICE, the police are very concerned about what to do. Do they follow state law But that means then they have to go against this brotherhood of law enforcement between them and ICE that they've been told for 25 years. These are your law enforcement brothers, and they strongly believe it. And so that's a good question. We'll have to see how that plays out.
Okay, I'm not going to repeat the questions that you answered already in the chat, and we will share the chat. So, how is the ACLU planning to assist municipalities to create and/or update policies after the PROTECT Act is passed?
So in most of the municipalities, towns, and cities, I mean, we have to remember that Massachusetts has a little more than 350 towns and cities. The ACLU has been the one writing and most of those policies and most of those codifications. So as I said, I think at the end of the PowerPoint, you can, the ACLU is, as soon as we get the Protect Act out, we're going to update the model ordinance so advocates can use that, and we're going to come out with a toolkit. But also, I specialize in municipal work. I have my colleague Sarah Brown also specialized with municipal work. And many times what we do is going to the municipalities, we work really close with advocates, and we help to negotiate, to work with their champions. If they have somebody in city council who is willing to introduce it, we help the people to navigate. Each municipality is a different animal. Parks and Rec was a documentary, a real one. So we help with all that to advocates. I'm gonna put my email address if anybody's interested to touch base related to that.
Thank you both so much. I think I'm turning it back over to Sarah.
So I'd like you all to, you're muted. I'm the only one that's not muted at this point, but please use all the emojis to thank Josh and Javier for this excellent, excellent presentation. Josh and Javier, your presentation and your remarks were very well intertwined. Javier, you provided the historical foundation for our discussion tonight, the historical context, taking us back to 9/11, when this intertwining of federal agencies and state and local authorities began. Josh, excellent job presenting the findings in detail, the recommendations in detail. I want to reiterate what Josh said, I think 2 or 3 times, so you're going to hear me say it a 4th time, and that is that the PROTECT Act is a floor. I hope that we can bring you back on another occasion. Javier, thank you very much for presenting both the Senate and the House version of the PROTECT Act. Many of us have been following it and have been advocating for the passage of it, and have been talking regularly to our legislators. And we're hopeful that this will pass soon. But again, it is a floor. We have a lot of work to do with you, and we hope to collaborate with both of you in the future. We're spread out over the state. There's indivisible groups all over the state. And I think that we can collaborate well with you. We're very interested in doing some of the local education, Javier, at the municipal level, since that's where we're located in various cities and towns. I think everyone would join me in wanting to welcome you back on another occasion to update us once the PROTECT Act has been passed. And to talk with us more about things that it doesn't address that you mentioned, Josh, such as fingerprinting and DAs. So on behalf of all of us, thank you very, very much for an excellent presentation. To all our participants, we mentioned in the chat that we're going to get all kinds of information to you, the 2 PowerPoint presentations. I think Todd dropped into the chat a few times, the report, the ICE Out report. I recommend it very highly to you. Josh will want to get the updated version of your toolkit when it comes out. We'll be in touch with all of you. thank you very much to all of the participants who joined us tonight. And again, Javier and Josh, thank you very much. Muchísimas gracias.
Thank you so much.
Thank you.